Hello everyone, welcome back to my channel. I wanted to do a video about the latest corruption of the FBI, which is not surprising to me, probably not surprising to many of you guys who are regular listeners of my channel. It has just come out that the FBI was engaging in obstruction of justice in the Proud Boys seditious conspiracy trial. Now, you could argue that the Proud Boys case, along with the Oath Keepers seditious conspiracy cases, are the two biggest cases to stem from J6. So these are the biggest cases, and you would think that they would handle them properly, or they would at least attempt to, knowing that they've made very insane allegations about these defendants. Now, as you guys know also, many of the J6 political prisoners are being denied their rights as American citizens. They have been, many of them, held in pre-trial detention for going on 2 years now. They have not been convicted of a crime. Most of them have, completely innocent backgrounds, like they've never been in trouble with the law before. They don't have a prior criminal record, no history of violence. This is, for many of them, the first time they've ever been in trouble before. So for these judges in DC to argue that there's somehow a risk or danger to their community is ridiculous. It's very clearly political. We know the FBI has said this is one of the biggest investigations in the history of the FBI, which is also quite telling, right? As far as like shutting down organized crime or transnational crime in general. This is what the FBI is more interested in spending their time on. But let's go ahead and get into it. There's a couple things we're going to cover today in this video. Let's go ahead and bring up the first thing here. This is coming from Julie Kelly. She is an editor at American Greatness. Breaking: drama in the Proud Boys trial yesterday after FBI agent caught lying on the stand and concealing evidence from defense attorneys. Okay, so right there, we know the FBI is breaking the law and they're trying to hide evidence. This is exactly what happened in the Whitmer case. And so it's obviously a pattern of behavior for the FBI as well as the DOJ and their prosecutors. Motion filed this morning from Nick Smith, attorney representing Ethan Nordean. He is one of the Proud Boys that is being charged with seditious conspiracy. This is what happens when a rogue, corrupt FBI is allowed to lie to the public, withhold information, and operate without oversight by Congress. Yeah, the FBI has basically no oversight. So let's go ahead and read from the document. Today, government witness Special Agent Nicole Miller was cross-examined. She testified that she understood her legal duty under the Jenks Act to produce to the U.S. Attorney's Office written statements relating to the subject matter of her testimony. 18 U.S. Code Section 3500. Miller acknowledged that among those statements were messages she sent in the FBI's internal messaging system called Link, where Bureau employees communicate with one another. She testified that in order to comply with her Jenks obligations, this is part of the discovery obligations, she compiled her Link messages in an Excel spreadsheet, which was then produced to the U.S. Attorney's Office. Now, I'm going to just say, why are we entrusting in a federal major case like this? Why are we just trusting this FBI agent to compile her own messages, to produce, the evidence here? Why isn't this being done by somebody else at the FBI or with the U.S. Attorney's Office? I don't think we should just be trusting these FBI agents to be completely transparent and honest. Like, where is the oversight here? That's just crazy to me. So, oh yeah, we're just going to trust that she's going to put all the correct messages in an Excel spreadsheet. So if, for example, she is in this FBI internal messaging Link system and she's communicating communicating with other agents about, I don't know, maybe rigging a trial, she probably would know. She'd be smart enough. Hey, like, I don't want to incriminate myself. I'm just not going to produce those messages. Of course, she'd hide them. So it's just stupid the way this whole thing is being done. The version of Miller's Excel sheet produced to the defense contained 25 rows of her link messages. In cross-examination, the agent acknowledged she alone compiled that disclosure. So again, we're just trusting the FBI here. She testified that those messages constituted a complete production of her Jenks statements from Link. However, a close examination of the agent's sheet revealed over 1,000 hidden Excel rows of messages. Miller was thus examined as to whether she had withheld from prosecutors link messages concerning, number one, a conspiracy charge was factually supported in the Proud Boys case. This agent or someone deleted thousands of messages in the FBI's link messaging system, messages relevant to investigation and required to be produced to the defense counsel. Unbelievable. What messages did the FBI conceal from the defense team? A request by an FBI informant to alter an official CHS report. You can see right here an agent's request to Special Agent Miller to, quote, go into a CHS report that Miller, quote, just put together and edit out that the agent was present. You need to go into that CHS report you just put and edit out that I was present. Of course, edit out that I was present. Brazen lawlessness at the FBI in its biggest J6 case. Boss instructs FBI agent to destroy hundreds of items of evidence. Is this a slam dunk case of seditious conspiracy? Why is the FBI destroying and hiding evidence? Miller's communications with another agent who states that the agent's FBI boss assigned her 338 items of evidence I have to destroy. Unbelievable. From the hidden rows in Miller's link spreadsheet, it is apparent that the defense has not received all of her Jenks statements in those relevant communications. That is because the individuals with whom Miller exchanges messages can be seen responding to the agent, but her own statements are missing. So we know she deleted her replies. Even more egregious, maybe, the FBI accessed emails between one defendant and his attorney and discussed its contents. This agent apparently knew one defendant planned to go to trial. Oh, like instead of taking a plea deal, the judge excused the jury as soon as this information was revealed in court yesterday, hearing shortly. So there is going to be an update on this story. But I mean, guys, this is just insane to me that this is happening. Finally, Nordean must be permitted to cross-examine Miller with the hidden link messages to determine whether defendants' Sixth Amendment rights have been violated through government collection of attorney-client communications about trial strategy. So lawyers and their clients are supposed to be able to communicate privately so they can craft their own and prepare their own defense. They're going through evidence, they're coming up with their own strategy at trial, and that relies on confidentiality. That is why it's called attorney-client privilege. Now, the FBI is completely disregarding that in order to rig a trial. They're trying to go find what the defense strategy is going to be, what evidence they're going to use, what information that's going to come out at trial, and then they're trying to take that and prepare for the trial to complete. It's like designing a trial to just try to destroy the defense strategy. It's completely illegal. They're not allowed to do it, but here they are doing it. And I guarantee no one's going to be reprimanded for this at the FBI. No one's going to be held accountable. Okay, so Defendant's Sixth Amendment rights are violated when, quote, the government gained access to the substance of the attorney-client communications and thereby created at least a realistic possibility of injury to the defendant or benefit to the state. Exactly. By email to chambers, the government argues that the attorney-client privilege is waived whenever a defendant communicates by jail, email, or phone with his counsel. That is obviously wrong. So the Department of Justice here and the FBI are trying to argue that defendants that are in jail don't actually have a right to attorney-client privilege. That is ludicrous and patently false. Of course they do. There are many criminal cases where you have a defendant in jail and they still retain attorney-client privilege. Just amazing stuff, guys. Just amazing. So, moving on. There's more. More breaking news in Proud Boys trial. Defense attorneys filed to dismiss the case based on revelations in the Tucker tapes and FBI concealing and doctoring evidence. Well, guys, the FBI admitted to planting evidence in the Whitmer hoax case. They actually said at trial that they planted evidence on Barry Croft so they could later seize that evidence when they arrested him. And nothing happened. Like, they just admit to planting evidence on people. It's crazy. Defendant Pezzola, this is Dominic Pezzola, a motion for dismissal with prejudice, or in the alternative, a mistrial regarding recent revelations on Tucker Carlson and associated testimony and the discovery of massive Brady and Jenks violations and violations of due process and the Sixth Amendment. Defendant Dominic Pezzola, by and through his undersigned counsel, Roger Roots and Stephen Metcalf, hereby move the court for dismissal of the indictment in this case with prejudice due to recent revelations on Tucker Carlson and associated testimony on Thursday, March 2nd, as well as due to Jenks and Brady violations revealed on March 8, which established that the prosecution has been monitoring attorney-client communications of defendants, destroying evidence and doctoring and fabricating evidence involving CHSs, confidential human sources, yes, friends, that's FBI, informants. This is why a compliant media, Chuck Schumer, Mitch McConnell, etc., are melting down. I can only imagine what's happening at DOJ over Tucker tapes. Defense attorneys continue to argue they need access to all hidden footage. Yes, exactly. Then came the Tucker Carlson show on the evening of March 6. On March 6, Tucker Carlson released shocking footage from J6 that showed Jacob Chansley walking calmly through the halls of the Capitol, accompanied and being escorted by two Capitol police officers. At one point, one of the officers appears to try opening a door or elevator and then turns and leads Chansley in another direction, literally giving him a guided tour of the building. Later in the video clips, Chansley is seen walking past 9 police officers gathered in a hallway intersection. Chansley and his police escort walk right past 9 officers without any resistance. If this guy was doing something wrong, why didn't these cops arrest him? There's a reasonable inference on the part of Jacob Chansley that if the officers waved him into the building and are escorting him around, showing him different offices, that he's got permission to be there. I'm assuming, and I think any reasonable person would assume, if you're standing in a building and you walk by 9 officers, if they don't want you there, at any point, those officers could have escorted you out of the building. They could have asked you to leave. None of that happened. So it is not unreasonable for Chansley to assume that he is being given permission by the Capitol Police to walk around. Then Tucker shows footage of officers calmly escorting Chansley and apparently other protesters into the Senate chamber. The Washington Post wrote that Albert Watkins, Chansley's attorney through sentencing in November 2021, said he'd been provided many hours of video by prosecutors, but not the footage Carlson aired Monday night. He said he'd not seen video of Chansley walking through the hallways with multiple officers. Quote, "What's deeply troubling," he said, "is the fact that I have to watch Tucker to find video footage which the government has but chose not to disclose, despite the absolute duty to do so, despite being requested in writing to do so multiple times. Pezzola likewise has had a right to the same footage, yet the government has withheld it. The most disturbing footage of all, from the perspective of Pezzola, is a video of Chansley kneeling in prayer where he says he's thanking God for the inspiring the officers, the U.S. Capitol Police officers, to let people inside the building. It's unbelievable. More confirmation here about the FBI agent who lied on the stand yesterday. That's perjury and concealed evidence. Quote, "Admitted fabricating evidence following orders to destroy hundreds of items of evidence. Lack of criminal accountability for FISA-gate lives." Exactly. They got away with it in 2017. They continue to get away with it now. Then in the afternoon session of trial March 8, it was revealed the FBI has been monitoring privileged communications of co-defendant Rel and his attorney and discussing Rel's case strategy among each other. These revelations came out as co-defendant Ethan Nordean's counsel Nick Smith cross-examined FBI Special Agent Nicole Miller. Smith revealed that a secret hidden tab in an FBI spreadsheet showed some of Agent Miller's emails, in which the FBI agent admits to fabricating evidence and following orders to destroy hundreds of items of evidence. Right there, that right there is grounds for a mistrial in the Proud Boys seditious conspiracy case, and I would argue the Oath Keepers as well. We'll get to that, though, momentarily. Yes, this case should be dismissed. If justice means anything, it requires this case to be dismissed. Concealing evidence, doctoring evidence, destroying evidence, violating attorney-client privilege. What's sad is this will be ignored even by conservative media and Congress simply because these gentlemen are members of the PBs. That's not a crime, no matter how many times Ray says it is. In the Nordean case, confidential attorney-client trial and defense strategy and position was wrongfully obtained by the government, which was overheard, shared, utilized, where potentially 338 items of evidence were ordered to be destroyed. Unreal. Okay, so that's unfairly prejudicial to the defendants, and hopefully something will be done. J. Michael Waller here says, FBI agent lied under oath yesterday in a federal prosecution trial. Admission of FBI fabrication of evidence following orders to destroy hundreds of items of evidence, deleting exculpatory evidence from the FBI's own link internal messaging system, and more. Judge excuses jury. The FBI is a bigger mess than we can imagine if it conceals, destroys, and otherwise tampers with evidence and lies to support prosecuting a defendant in a case described as one of the worst since the Civil War. Yeah, exactly. Which, again, is utterly ridiculous. The Gateway Pundit has picked up on this and put out an article. Sources say FBI agents colluded to illegally intercept PB defendant communications with his attorney. Attorney-client privilege demolished. Paper trail exposes agent and DOJ. Exactly. A compromised FBI agent took the stand yesterday at the PB trial to testify for the prosecution. It was revealed in cross-examination. FBI agent Nicole Miller had intercepted strategy notes between the defendant Zachary Rel and his defense attorney Jonathan Moseley, and clearly intended to continue to violate attorney-client privilege to aid the prosecution before trial. So not a fair trial, friends. When defense counsel Nick Smith took the podium to begin his cross-examination, he stunned the courtroom with a shocking revelation. found an email thread with Rell and his attorney Mosley. The attorney raised some interesting points. I need to find other emails, but this one email definitely indicates they want to go to trial, but don't freak out Jason and Luke yet. Implied they would share with prosecution. That is Special Agent Miller talking to another agent at the FBI, admittedly spying on defendants and their lawyers, saying, oh yeah, we're reading the lawyers between the defendant and his attorney. Unreal. Jason refers to Jason McCullough, lead DOJ prosecutor in the PB seditious conspiracy case. Zachary Rell, one of the PBs currently on trial for quote unquote seditious conspiracy. Apparently, Miller was illegally intercepting messages between a prisoner and his attorney that were sent on the prison messaging app core links from his jail cell. This is a direct violation of the 6th and 14th Amendment of the U.S. Constitution. Attorney-client privilege is one of the oldest and most respected privileges of being an American citizen. Not only did the criminal FBI agent Miller intercept emails, but according to her own text messages with a fellow agent, she was looking for more, which she intended to give to the prosecution. Outright collusion. Quote, when the feds or any investigative agency determines that the communication is clearly between an attorney and their client, they should cease to monitor or record that communication and should not utilize any information based on those communications for their own benefit, said PB lawyer Steve Metcalf. Quote, they should stop monitoring or listening to that communication. That's the Constitution. When the feds exceed those bounds, they are violating a defendant or individual's Sixth Amendment rights without question. And if they use that as part of the prosecutor's case, they are gaining an unfair advantage, which is detrimental to a defendant and should be deemed a violation of their rights. And that is grounds for dismissal of the case, in my opinion. It is grounds for a mistrial. According to sources, a young legal assistant working for attorney Smith found this shocking evidence, and Smith was able to use it to dismantle the star witness FBI agent in seconds. As soon as Smith called out her illegal activity and began exposing the agent, all HELL broke loose in the courtroom. Masked prosecutors started having meltdowns, jumping out of their seats with wild objections after every sentence Smith uttered. Prosecutors demanded sidebars on the court phones and frantically tried to stop Smith's line of questioning. To be expected, the dishonorable Judge Kelly, sadly a Trump appointee, stopped the trial for the day and told the jury to go home early. Witnesses in the courtroom speculate the judge was protecting prosecutors from being caught in possible illegal conduct and gave them the evening and night to concoct a crafty way out of their mess. That's exactly what happened. He also saved the witness, the lying FBI agent Miller, and bought her extra time to regroup with her FBI superiors and strategize. Yes, he should dismiss the case, and that judge himself should be removed from the bench, in my opinion. He's outright putting his hands on the scale to assist the federal government and the FBI and the prosecutors in their railroading of these defendants. It's outrageous. You know, at what point? We have right now a committee investigating the weaponization of the federal government, namely the FBI, against one side of the political aisle. Right here, once again, we have just documented evidence. It's there. The evidence is there. Is anyone going to call this FBI agent into the weaponization committee so she can explain what's happening here? I mean, all of these cases are under question now. All of them. All of them should have grounds for appeal. Every single J6 defendant should have grounds for appeal in this case. That's my personal opinion. Now, I'm not a lawyer, so this is not legal advice. But if I was a J6 defendant, I would be getting together with other J6 defendants and their lawyers and trying to strategize a civil rights class action lawsuit, because I believe they have one. Okay, attorney-client privilege is one of the most powerful rights in the Sixth Amendment, as part of the right to counsel, you have a right to have private conversations with your lawyer that is not being listened to by the government. There is a lot of case law that says if an FBI agent accidentally finds they're listening in on attorney-client conversations, they're supposed to stop and cease listening. In this case, they have intercepted emails between a defendant and his lawyer. Furthermore, they are supposed to disclose the fact that they had intercepted these communications to the defense, because that is part of discovery evidence, and it is a Brady violation if it is not disclosed. So we already have here evidence of misconduct, and I guarantee nothing's going to happen. Thankfully, the jury was present when Agent Miller was exposed. Unfortunately, though, this is a DC jury, and I don't trust them, so I think that the judge has the duty to dismiss this case with prejudice. Okay, so let's just move on. I'll include all of the links, by the way, in the video description, but here is an article from Julie Kelly regarding that judge, Judge Tim Kelly's contempt of court and the other things he's done. Now, this article is from February of this year. This just shows you some of the more egregious examples of him basically doing things to benefit the federal government, the FBI, the DOJ. This was prior to this information coming out, so it wouldn't surprise me, if he doesn't dismiss this case. But still, they'll have grounds for an appeal. Then I wanted to bring up this article because while this article is really long, it is very, very interesting, and it does involve the Oath Keepers and the PBs at a certain point in disputing the official narrative here. So I encourage everybody to read this. It provides a different story than the government narratives on their two big seditious conspiracy cases. This shows Oath Keepers apparently assisting a Capitol police officer. Very interesting stuff. We also have this. This is, again, unsurprising. This comes from Wired. Let me just zoom out so everyone can see it. The FBI just admitted it bought U.S. location data. Rather than obtaining a warrant, the Bureau purchased sensitive data on American citizens, a controversial practice that privacy advocates say is deeply problematic. So they're supposed to have probable cause, and then they're supposed to use that probable cause to obtain a warrant signed from a judge before they're able to intercept data on American citizens. You have to have a reason for that. Otherwise, it's just warrantless surveillance, which is what the FBI has been doing for a very long time. This is unsurprising, but I just thought, yeah, this just broke yesterday. So once again, it's just scandal after scandal with this FBI. We do have some good news, though. This comes from just this week. The Heritage Foundation has announced an oversight project to sue the FBI. Double standard driven war on conservatives must stop. The Heritage Foundation's oversight project announced Monday it has filed 7 federal lawsuits against the FBI following the agency's failure to produce documents in response to lawful FOIA requests. The FOIA lawsuits concern a pattern of disturbing and partisan behavior at the FBI, surveilling American social media users without requisite legal process. Well, we just showed you the article from Wired showing that the FBI is doing, once again, warrantless surveillance without any due process, without obtaining a warrant from a judge. They're just buying the data from third-party providers. Inappropriate resourcing during the 2020 BLM riots, in which cities and counties reported that they experienced 2,385 incidents of looting, 624 incidents of arson, 97 police vehicles burned, and more than 2,035 injuries to law enforcement officers. FBI partisan participation in these events. We all saw them taking a kneel. Nellie Orr, Fusion GPS anti-Trump researcher who had a part in creating the quote-unquote Steele dossier, may have avoided surveillance and potentially misled Congress concerning this fact. pulling FBI agents off cases involving V crimes in favor of working non-V J6 crimes, and applying grossly different criminal standards to former President Trump versus Biden regarding classified record disputes. So they're going to be suing the FBI. It'll be interesting to see if we get any what we get in discovery from this. So each one is listed here. You can go look at the complaint of each case. I think it's interesting to follow up on this stuff and see what information that the FBI is withholding from these FOIA requests, especially regarding their participation in partisan protests. I find that to be very interesting. So anyways, that's where we are today. We are with the FBI destroying evidence, deleting evidence. FBI superiors telling their agents, hey, in our biggest case related to this whole J6 investigation, the seditious conspiracy case where people are facing felony crimes and 20 years in prison or more, hey, let's fabricate evidence, let's destroy the exculpatory evidence, and let's also spy and listen in on privileged attorney-client communications. As Michael Sherwin in this picture said, oh, we had a shock and awe campaign. Michael Sherwin was an assistant U.S. attorney who, in the wake of J6, while speaking to CBS News 60 Minutes, he did an interview in which he himself said that immediately following J6, the next day, they started arresting people in very tactical SWAT-style pre-dawn raids in what he characterized as a shock and awe campaign. Now, he said they did this because they were concerned that people were going to protest Biden's inauguration. So they wanted to do this shock and awe campaign to scare people, to have a chilling effect so no one would protest the inauguration on January 20th. Which is interesting. So again, they arrested all these people before they had any evidence on them. And then once they arrested them, then they're looking back and trying to find evidence on these people. And again, some of them have been held for over 2 years now and haven't even gone to trial yet. Well, the government has just recently admitted that they haven't even uploaded all of the discovery into their system yet. So why have you arrested these people if you haven't prepared your case in advance? That is ridiculous. And let's not forget also the following.
I think as a former federal prosecutor and a public defender who defended a lot of these types of cases.
So this is Kash Patel. He is a former Trump administration official. He was just on Timcast and he was discussing some of this stuff as well.
What you need to show is whether or not the FBI and government agents were using undercover operatives and informants on.
Now he's talking about their pre-knowledge of what happened on J6. Hey, you know, did they have undercover operatives there that were instigating, right? Kind of like agents provocateur. We know that, in fact, and that's something that I wish would have been brought up on Timcast. We know, for example, from the Phi Duong case, that there were undercover FBI and MPD officials present on J6 that were engaging in conversations with people like Phi Duong, who they chose to monitor after J6. They did not arrest him for trespassing at that point yet, for meandering inside for 20 minutes. They infiltrated his Bible study group and tried to get them to do a DT. You know, I'll put the gasoline in the jar, but he wouldn't put the gasoline in the jar. But we do know from those documents that they did have undercovers present that day. I have been reporting that since I think it was April 2021 when the Phi Duong case came out. And I wish people would reference that more often when they discuss this notion and possibility of federal pre-knowledge and involvement on that day. We have in documented court evidence that that is indeed the case.
On the day of January 6th, because if you can show that, you know they've been out, hang on, but the paperwork shows having run informants, that's a 6-month buildup, minimum.
Right.
Minimum. It's not like they just dropped them into the Proud Boys and said, hey, go, don't disrupt, please. So once you prove that, then you defeat the insurrection narrative with the FBI's own documentation. Forget what the videotape shows.
Just for people who you can't see what's going on in the room, the reason why Cash just said hang on or whatever is because I started smirking and rolling my eyes. And what I meant to convey with that is, come on, we know they were involved.
No, look, I totally
clarify,
agree.
Though.
Yeah.
I'm not saying I know definitively. What I'm saying is A reasonable suspicion is that there were agents. There's a video showing a guy with an earpiece pulling people into the building.
Not only that, there are people with walkie-talkies. There are people that are filmed that are very obviously working for someone and coordinating with others on the ground that day.
All right. You combine that with the evidence of Ray Epps, and it looks like you have a preponderance of evidence suggesting there may have been federal law enforcement involved in making that thing happen.
I'll get you beyond.
Again, we know from the case of Phi Duong, it is documented, it's in court documents from discovery, that there were undercover FBI and MPD present on J6 that day.
A reasonable doubt. Two pieces of information. Ray Epps was on FBI's most wanted list one day, and the next day he was off of the FBI's most wanted list. There are only two ways that happens. You die, or your informant. Put that aside. Under congressional testimony, Jill Sanborn, who I used to work with, the head of the FBI Counterintelligence Division, in charge of all these investigations, testified under oath when Senator Cruz asked her, flat out, were there federal agents involved with January 6th? And she said, quote, Senator, I can't answer that at this time. Not if the answer was definitively no, having been a DOJ FBI guy myself, she would have gone there and said, nope, absolutely not.
Exactly.
The reason she said I can't answer that is because of the same stonewalling they gave us during Russiagate with Christopher Steele, Halper, and everybody else. It's the same narrative, and I'm telling you they were there.
So you're saying that she said I can't answer that because the answer is yes, and that would compromise whatever their operation was.
Exactly. I think as a
Duh.
Here's the thing. The FBI was asked if they used agent provocateurs on January 6th, and they refused to answer. I'm sure you've seen that footage.
Yes.
Yeah. And they know about that guy, Ray Epps, that was on the Capitol grounds saying, we got to go in there. And people calling him a Fed, and nothing's happened to that guy. Nothing's happened to that guy.
Exactly.
But the guy was clearly inciting these people to do something illegal, and they know who he is.
And they have it on tape.
Yeah, they have it on tape. It's all very wild. The fact that that is a practice, that they hire people to go and rile people up to go do illegal things.
Yeah, it's called the Whitmer case. They hired people and created an entire theatrical production to try to frame people for a conspiracy to kidnap. And just to, at the end of this video, just wanted to shout out my documentary, which is still ongoing right now. We're still fundraising for it. It is about the FBI's Governor Gretchen Whitmer Fednapping hoax. The documentary is called Kidnap and Kill an FBI Terror Plot, and you can find its channel. Its official YouTube channel is K&K Film Official on YouTube. It's on Twitter at K&K Film Official. You can just go to kandkfilm.com, which will redirect you to the Give, Send, Go, our fundraiser page, where we have the trailer for the documentary posted. You'll get updates on the status of the documentary right now. As far as fundraising goes, we're trying to raise like $150,000 to complete the documentary, which sounds like a lot, but really it is not. I can assure you there are legal things that we have to do. We have to consult with lawyers. There's a lot of stuff that is involved in this. Now, I'm one person and I have an editor. I don't have a team of people helping me to get this done, but it's really important that we get it done. I'm committed to doing so. And I have about 5 or 6 more places I need to travel to for filming with different individuals. Right now, the next location I need to travel to, I do have to get plane tickets. I have to get an Airbnb. I have to arrange for travel and food while I'm there. But at the next one I'm going to, there's like 3 or 4 people in that one location that I can interview at once. So I can get 3 or 4 interviews done at one time. That is tremendous progress. So I'm trying to do this in the best way possible. What's the most cost-efficient way of doing it? So if you want to donate to that documentary, any donation, anything you can offer is appreciated, and any little bit helps, even if it's only a couple dollars, like $5 here or there, whatever. All of it adds up, and it all helps and contributes to me being able to complete the project. Right now, it's about 1/3 of the way done. And I don't mean the editing to finish the completed project of the documentary. I just mean going to places, traveling to places, and recording interviews with different people. We're about 1/3 of the way done with that. So as you can imagine, there's still again, like 5 or 6 different places across the country I need to travel to and interview different people. And then we take all that footage and we have to edit it together. I have to go through boxes and boxes of documents to kind of go through and dismantle a lot of this stuff. It takes a lot of work, is all I'm trying to say. A lot of time gets devoted to this. And so I'm working full time on something that I am not getting paid for, basically. Which is why we have to fundraise for it, because I'm spending my own money. I have spent a lot of my own money before I created the fundraiser on the documentary as like a passion project, because it's something I believe in. But at a certain point, I've run out of all of the money that I had saved. You know, I've already spent all of it with the documentary so far. So we had to fundraise to finish the project, and I really appreciate it. I saw somebody calling me a grifter because I haven't completed the documentary yet. Guys, I just started working on this at the tail end of last year. So the end of 2022, I had just started work on the documentary. And I'm, again, one person. I do not have a team of people. For documentary film crews who, number one, have experience and have done this before and have a team, it can take them up to 3 years to complete a documentary. So somebody accused me of being a grifter and said, oh, look, she's just going to keep that fundraising money and she's not going to do the documentary. It hasn't been released yet. I haven't even been working on it that long. It's only halfway done, not even halfway done. I still have to go to all these different places and interview and film with people. I have to go through tons of documents. I have to get all of this information together, and then I have to tell the story. I have to take all of this information and basically summarize it and all of that. It's a lot of work. So if anyone wants to volunteer to help out with that as far as research goes, or reading, hundreds of pages of transcripts, that would be great. You can reach out to me. I can get you in my server that I have for researching and just kind of helping me organize stuff. But that being said, of course, I'm going to finish the documentary. I haven't actually touched any of the donations that have been made so far to the film, not one. I haven't cashed out any of that money yet because I haven't finished fundraising, so I haven't spent any of it yet. If I can't fundraise to complete the film, there's no point in me taking any of that money, and I'll just return it. But I believe that we can get all of the money that we need raised to complete the project and get it done. So that's where we stand with the documentary, and it is really important because, as we saw from today's video, you have an organization that is completely unaccountable. And we always ask ourselves, what can we do? What can be done? How can we get Congress to investigate them? How can we have them held accountable? Well, the only real way to do that is to completely and utterly expose them, expose their crimes. And it would take something like a documentary, bringing all of that information to the public that can create the kind of, public pressure on our elected officials to really investigate the FBI. That's the whole purpose of the weaponization committee. So I would encourage it to do its job. You have right here evidence once again in the Proud Boys seditious conspiracy case, and I guarantee this, you'll find the same thing in the Oath Keepers case of the FBI fabricating evidence, planting evidence, destroying evidence, obstructing justice, spying on privileged attorney-client communications, and more. So anyways, with that being said, I hope everybody has a good day, and I'll talk to you all later. Bye.